everyone. Welcome to our week 11 preview video. I am going to, in this preview video, just very briefly go over some of the points that we finished in class yesterday, which was Thursday, about drafting the inter-office memorandum and working with IRAC, and get us set up for next week, where we're going to be doing some in-class work on how to draft your own IRACs. So just by way of review, I also just want to mention, please be sure to read the chapters in your textbook, mostly because they have some additional examples of what the memo looks like and the different parts of the memo. And as I mentioned before, I'm going to encourage you to use these memos as templates for you to follow. You're going to come up with your own words and your own way of writing. I expect you all to be, and you all are, your own individual writers. I don't expect everybody to write 1 + 1 is 2. But there's a lot of information that goes into writing a legal memo. And as one of you mentioned in class yesterday, staying organized is going to be key. So use the memo template that we'll talk about, and then also use the IRAC template. So just by way of reminder, the document that we are building up towards writing by the end of the semester is the inter-office memorandum. This is a document that lawyers and paralegals are very familiar with. It is a neutral, objectively written document whereby we in the legal profession can take our client's set of facts, and remember that can be a potential plaintiff, a potential defendant, even something that happens in the middle of a case. But we take the client's facts and then we research the applicable law. That's the case precedent, that's your statutes and your primary authority, your case law research. So we take the facts, we take the research, the precedent, and then we apply it together, and we bring them together in order to predict an outcome for our client. And again, we don't have the crystal ball, so we can't say, yes, 100% the client will win this particular point or will lose this particular point. But we have sophisticated education in the law, and we know that we can read precedent and predict an outcome. And that's why we'll use the word likely or probably instead of saying a resounding yes. And so now we're going to go through a little bit more about the memo and how we use the IRAC format in order to synthesize our legal analysis. So that's what I want to really focus on here. With the IRAC format, this is what IRAC stands for. I know you guys know this from class, but I want you to think about this as an organizational template. And another way to think about it is, at a minimum, an IRAC is one paragraph of writing. It begins with the issue sentence that is one sentence that concisely states the issue that you are going to analyze. The issue sentence could describe the big issue, as I mentioned in class. If you look at the Sack and Shop example, the big issue was negligence, or is negligence. Is Sack and Shop going to be liable for a negligence claim brought by an injured patron? Or it's stated in a sentence, the issue is whether Sack and Shop will be liable. And I gave you a sample issue sentence here on our Jesse Red Sox example. It concisely states that one issue. So it could be the big issue, but it also could be what we call a sub-issue. And that ties back to something else we mentioned in class, when we talked about the elements of negligence as being duty, breach, causation, and harm. And in order to answer the big question of negligence, we also need to answer the smaller elements of negligence. We need a paragraph just on the issue of duty of care, another paragraph and analysis just on the issue of breach, and so on and so forth. And we will do the same for the example that we're going to do in class next week, which, if you've already looked at the documents, you can see that it is a burglary case. And we're going to do the same thing with the elements of burglary, where burglary is our big issue and the elements of burglary are the smaller sub-issues. So the paragraph begins with one sentence that is the issue sentence. And again, it's only that one sentence. Now, here's something a little different about legal writing. After our issue sentence, the very next sentence needs to be a rule. And the key about understanding the rule section is that all of those sentences that you will write to describe the rule from your cited cases are exactly that. They are only sentences that describe your research. Do not resist the temptation to jump from your issue sentence to discussing your client. Now, I want to let that sink in for a second. So if you need to, pause the video and think about it. The tendency for many of us would be to say the issue is whether Sack and Shop is going to be negligent, or maybe the issue is whether a baseball club is going to be liable for injuries, whatever that issue sentence is. The tendency is often to immediately discuss what happened with your client's case, but we do it differently in the law. We always set up the existing precedent first. So now I'm going to take a little bit more time and go over in more detail about the rule to set us up for next week. The rule section should be at a minimum a one sentence, it should always start with actually, a one sentence takeaway rule from your cited case, from your research. It could be a statute also, but let's focus a little bit on case law right now. When you learned how to brief cases earlier this semester, we focused heavily on the holding of those cases, what the court decided. And we're already seeing how we rely on what courts decided in earlier cases to determine precedent for us. So what you should be looking for when you read your court cases as part of your research is you should be looking for that holding or that takeaway rule that you could lift up from that case and say, this is what I learned here. So then you can apply it to future cases. So there's a couple things embedded in that. Number one, I don't think I said this in class, but I'm going to say it now and repeat it later. This means that that case briefing step that we learned how to do earlier this semester is a necessary step in writing an inter-office memo. When you get to do your research, and here I'm going to give you the cases, but you'll have them in front of you. I promise if you have 3, 4, 5 cases that you think will help you answer a question for the client and you don't brief them, you're going to forget the critical details that are in them, because that's a lot. That's a lot for any of us. Even seasoned attorneys are not going to keep 5, 6 cases straight in their head unless they've read them, thousands of times. So my advice to you as we go forward and you learn how to put together your own research as you prepare to write the memo, brief the cases. If you brief the cases, writing this rules section becomes much easier because all the parts of the case brief go into this rule section. So let me state that again. You begin with the issue sentence. Your very next sentence is a one sentence takeaway rule from what you learned in your research. So as we talked about with the Costa versus Red Sox case, and we talked in class this past week, and we said, what did we learn? Well, we learned something to the effect of a stadium or a sporting arena does not owe a duty of care to warn spectators of dangers that are open and obvious, or something to that effect. We can phrase it a little bit more artfully. But notice I didn't say that, and therefore Costa lost her case, or therefore the Red Sox won. What I'm talking about is what is that takeaway piece that you now picked up that you can apply to other scenarios. That's your one sentence rule. Right after that, so one sentence for a rule, then immediately afterwards, a case citation embedded right into the paragraph. Remember, no footnotes, no endnotes. We always cite right into the paragraph, and we're going to do citation later. So you begin issue sentence, one rule sentence, citation to that rule. Now here's where it gets a little fun. Because we took this takeaway rule and we didn't say exactly what happened in Costa, we now move on and we add anywhere between, I wrote 2 to 3 sentences. It could be 1, it could be 4. That really depends on you. But a couple of sentences where you then, as part of the rule, you explain very quickly what the facts and the holding of that cited case are. So that way you can show your reader, here's the rule of law, and here's how it was applied in my precedent to reach the conclusion. This is why I said if you do a case brief of the cases that are most critical to your research, you will just be able to lift right from your case brief into your inter-office memorandum. So this is what it would look like. Here's your rule sentence. A ballpark owes a duty of care to warn spectators of dangers that are not, actually that's a terrible sentence. I must have had a typo in here. A ballpark owes a duty of care to warn spectators of dangers, but not ones that are open and obvious. Sorry, as I'm reading it now, I'm realizing there's a mistake in there, but I hope you get the idea. There's your rule sentence. And there immediately following it is my citation, Costa versus Red Sox. And then notice a couple of rule sentences. In Costa, a spectator who did not know the game of baseball was injured. She sued, but the court held the Red Sox did not owe her a duty of care to warn because this danger was open and obvious. And it goes on. Notice how that's just a couple of sentences that I would have pulled from my facts section and my analysis and holding from my case brief. So see how this rule is set up. We have an issue sentence, the rule, one takeaway sentence that is more accurate than the one I put here, citation, and then 2 to 3 sentences describing how that rule was applied in my precedent. I hope you're starting to see how discussing the case precedent first is now going to set us up for the A part of IRAC, which is analysis. Because we can't know what's going to happen to our clients until we tell ourselves and our attorney what the rule of law says. So if you're following, I hope you're noticing that I've written I've written a whole paragraph already, and I have not mentioned the fact of what happened in this Jesse example. I've just started with the issue and the rule. The analysis section is when we transition from the rule into the analysis. And by analysis, what we mean is tell us about our client, whatever our client's facts are, and use those details. Don't skim over and say, based on this precedent, the Happy High School is not liable. Use those details. Why do you think they are not liable? And you start with a transition word. You can start with in our case, or similarly, conversely. We'll use different transition words, but there's a key marking between setting up the law and moving into our particular client's facts. And that again can go on for a sentence, 3, 4 sentences, whatever we need. And here's an example. In our case, like Costa, Jessie was not very familiar with the sport. However, she did know that hockey could lead to injuries and so on. Notice that I used the facts from her case. So if you set up the law, then the facts of the client's case, and then you conclude your IRAC paragraph or analysis with a 1-sentence conclusion. And that should answer your issue sentence from the beginning of the IRAC paragraph. Whatever your issue sentence was, the conclusion should answer that. That therefore this element of negligence is met, or therefore this element of negligence is not met. There was no duty of care. So that's the flow of the IRAC paragraph. I say paragraph, you could move it into 2 paragraphs as it gets longer. We'll talk about that. But I want you to think about this as a structure that all legal writing uses to organize our thoughts. And then we can get really fancy, because if you have 2 cases that you're relying on that share the same point of law, you can discuss 2 cases in your rule section. And that gets really fun. All right, so take a look. Please pay attention to what I want you to prepare for next week. Take a look at Sack and Shop and go over the remaining IRACs in the discussion section so we can label them. And then for our in-class activity, I want you to read the burglary hypothetical that is in week 11 right here, and read only one case, Correa, the Commonwealth versus Correa case. Do not read the others. We have time to get to those. And think about what the You don't have to write a formal case brief, but think about the issue and the holding. All right, see you guys next week.